So hello everyone. I'm calling us to order. Welcome to the Industry and Technology Committee's 34th meeting. Pursuant to Standing Order 1082, we're meeting to study large and medium-sized, small and medium-sized businesses and competition. Today's meeting is taking place in a hybrid format pursuant to the House Order of Thursday, June 23rd, 2022. For members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raise hand function.
Last meeting on our study on competitiveness in the context of small and medium-sized businesses, we're honored and delighted to have with us as an individual John Peckman, consultant. Mr. Peckman, thanks for being here. We have from the Canadian Intellectual Property Office, Konstantinos Georgaras, and I'm sorry if I mispronounce your name, but thank you very much, and correct me going further, but thank you for being here. So Chief Executive Officer of the Canadian Intellectual Property Office. We have Iana Goyette, the Deputy Director, Policy and Legislation. We have Ms. Main-Pierre, Director General, Trademarks and Industrial Designs Branch. From the Institute for Research on Public Policy, nous avons Dr. Yves Blanchet.
We have Dr. Yves Blanchet, who's research analyst, and he's here with us in person. Thank you very much, Mr. Blanchet.
Laurier Institute, we have Aaron Woodrick, Director, Domestic Policy Program. So thank you all for joining us today for this last meeting on this study. And we will now begin with the opening remarks from Mr. Peckman for 5 minutes. So the floor is yours, Mr. Peckman.
So thank you very much for the invitation to appear here today. Before I begin, I think it's important to say that I'm here speaking in my personal capacity. My comments are my own and do not necessarily reflect the views of Fasken or its clients, where I currently serve as a senior business advisor, nor the Chamber of Commerce, the Canadian Chamber of Commerce, where I was recently appointed a fellow to write an independent report on the future of competition policy. During my career at the Competition Bureau, I received 34 and a half years of extensive hands-on experience enforcing and administering the Competition Act. It was a privilege to serve as the Commissioner of Competition for a 5-year term. Since leaving the Bureau, I have primarily been advising business clients on the functioning of the Competition Act and the Competition Bureau. Many of the comments today in my opening statement have been sourced from an article I wrote while Commissioner entitled Unleash Canada's Competition Watchdog, Improving the Effectiveness and Ensuring the Independence of Canada's Competition Bureau. It was published in September 2018. I like to believe this article has helped inspire some of the new competition policy reformers in Canada. The thesis of my article was that the competition policy, design, and administration is due for a facelift. My understanding is the current hearing is studying small and medium enterprises, SMEs. A properly designed and implemented competition policy will enable this sector to more fully participate in the economy and stimulate economic growth, innovation, and job creation. Barriers, either from excessive regulation or from anti-competitive conduct in markets, harms competition and Canada's international competitiveness. The Competition Bureau, through its enforcement and advocacy remits under the Competition Act, protects and promotes a competitive and innovative marketplace, and by extension, all SMEs in Canada. A strong competition law can protect SMEs by deterring dominant companies from adopting abusive or other anti-competitive practices. SMEs also benefit from the low cost of inputs that occur in a healthy, competitive economy. This June, the government implemented amendments to the Competition Act to address concerns about market concentration, among others, while maintaining the fundamental principles underlying the Act. Although not perfect and done without consultation, these amendments provide a good start to the government's reform of competition policy. The current Commissioner of Competition Policy, or Competition I should say, Matthew Boswell, has highlighted the need for a competitive domestic economy to increase Canada's productivity and international competitiveness. I wholeheartedly agree with this proposition. And some of the key additional competition reforms I am advocating for are as follows. First, the creation of an independent competitiveness council in Canada, which would advocate for more competition and less regulation in markets to improve Canadian competitiveness, as recommended by the Competition Policy Review Panel in 2008. Second, safeguard the Competition Bureau resources and provide it with a stronger voice to advocate for competition by making it a truly independent law enforcement agency, similar to the Office of the Privacy Commissioner. Third, strengthen merger control by reforming the efficiencies exemption and by adding other pro-competitive factors to be considered in assessing the prevention or lessening of competition. These factors could include new economic activity in Canada generated from a merger, such as employment, investment, dynamic efficiencies, research and development, and exports from Canada. Fourth, limit further expansion of the abuse of dominance provisions at this time to test the effectiveness of recent amendments. We should continue to monitor proposed legislation that is being proposed abroad aimed at dominant digital platforms in the EU, US, and elsewhere. Many of these reforms introduce regulations to tame alleged market power, which may have unintended consequences such as dampening innovation and investment in the digital sector. Digital technologies and markets evolve rapidly, requiring Competition Bureau to make and take immediate remedial action to minimize competitive harm. I believe the Bureau should be given new tools, such as streamlined injunction powers, which would allow it to investigate and dispose of cases in a more expeditious manner within the existing legislative framework. Lastly, sectoral market studies are the primary method the Competition Bureau advocates with governments and regulators for greater competition, such as identifying reforms to sectors with unnecessary restrictions on competition. There are currently no express powers in the Competition Act that allow the Bureau to undertake market studies or provides them with formal powers to compel production of information for these studies. However, as they can be burdensome to businesses, market study powers must be reserved for appropriate cases and incorporate procedural safeguards. I look forward to taking your questions. Thank you very much.
Merci beaucoup, monsieur.
Thank you very much, Mr. Pickman. I now turn to Mr. Georgaris of the Canadian Intellectual Property Office.
Yes, thank you, Merci beaucoup. I just want to confirm that you can hear me well. We did have some audio issues before. Is that good, clerk? Yes. Right, thank you very much for the invitation to speak with you today about SMEs. My name is Konstantinos Georgaris. I am the interim Chief Executive Officer of the Canadian Intellectual Property Office, a special operating agency of Innovation Science and Economic Development Canada. I understand that the committee is interested in particular in looking at trademark activities in Canada, so I would be pleased to speak to that. And I'm also joined by the Director General for the Trademark Industrial Designs Branch, Mesmin Pierre, as well as Yana Goyette, the Policy Director. I would like to start off by providing a brief overview of the clients and Canadians we serve, followed by the specific trends in trademarks, and what we have done to improve services and respond to surging demand. Overall, we receive over 112,000 applications for IP annually. That's for patents, trademarks, industrial designs. We received in 2020 over 34,000 patent applications, almost 70,000 trademark applications, and over 7,000 industrial design applications. That's the annual inflow. Because IP lasts for several years, for patents up to 20 years, and trademarks are renewable indefinitely, there are over 800,000 IP rights in force in Canada. So the impact is vast, and we are honored to serve these companies and individuals. For patents, this represents innovators who are bringing science, technology, research, and development to the market to serve Canadians. For trademarks, this represents companies working to establish their brand, goodwill, product recognition, and consumer confidence. So IP rights provide the tools to help these creative entities get to the market with confidence. And IP rights also help them monetize, collateralize, protect, trade, and license their ideas. I would like to note that this is very much an international space. Innovation is global, and IP likewise is global. So with that, over 70% of all of our IP applications come from outside of Canada, mostly from the US, Germany, China, UK, France. Likewise, many Canadians file in for IP outside of Canada, and this includes the US, China, Europe, and Mexico. To better understand the clients we serve, their challenges and opportunities, we had the opportunity to participate with Statistics Canada on the IP Awareness and Use Survey that was released just last year. That survey interviewed 16,000 companies. I would like to highlight a couple of positive outcomes as well as some challenges. We found that 58% of companies were familiar with IP, and that 18% held at least one form of IP. I'm sorry, do we have a technology issue here?
We seem to have a bit of a challenge. The sound is okay. The video, though, is lacking. Maybe if you turn off your camera and try to... Oh.
Unfortunately, the camera is not working.
Okay, but we can still hear you, so maybe we...
Perhaps I can continue?
Yeah, I suggest you continue, Mr. Georgas.
Thank you. So as I was mentioning, this survey of 16,000 Canadian companies revealed that 58% of companies were familiar with IP and that 18 held at least one form of IP. Similar to other surveys, we confirmed that IP ownership is more present in high growth firms and those who innovate and export. What is particularly interesting about this survey is that we asked companies directly how their use of IP contributed to their business. And almost 60% of all firms recognize at least one contribution of IP, and this included increased business value, increased revenue, expanded markets, increased business collaboration, and increased employment. So these are the companies themselves telling us that the use of IP has led to direct benefits. We also asked what challenges companies had in terms of seeking IP. While 86% of respondents did not experience difficulties in filing, 14% did indicate some challenges, and two in particular. One was with regard to complexity of the process, and the other was with regard to the time to acquire IP rights. So we're conducting a deeper dive into the survey results and developing approaches to address these two areas specifically, as we've been doing for a number of years. So with regard to complexity, seeking IP rights, of course, is a complex process. But we are using the results of this survey to identify differences across regions, technology areas, and with respect to underrepresented groups. And we're using this to help target our IP awareness programs, again, which provides information to help people understand and use IP. And we work in close collaboration with many partners across Canada. Specifically with regard to the challenge of time to acquire IP, as the overall demand for IP and pace of innovation continue to rise, the timely delivery of quality IP rights is critical for success. So specific in the area of trademarks, a number of factors have converged to bolster this demand. First of all, there's been continual growth for trademarks over the past decade. In 2012, there were approximately 50,000 trademark applications. I mentioned in 2020, it was up to 70,000. And in fact, during the pandemic, that has increased even more. So last fiscal year, we had 80,000 trademark applications. So that represents about a 60% growth in the last decade. Another factor here, very important, is Canada joined an international treaty for trademarks called the Madrid Protocol, which allows companies to file in many countries simultaneously. This has led to a robust international demand. And in fact, in 2020, which was the first full year where Canada was a member of this international treaty, the Madrid Protocol, fully 27% of our applications came through that treaty. And Canada ranked 4th in the world for Madrid applications. And then the final point in terms of surging demand is we know that trademarks historically have been linked to GDP. But we found during the pandemic, when we early on expected that there would be a reduction in trademark applications, in fact, what we witnessed was a difference and a delinking of that trend over time. So applications remained resilient in Canada, despite the economic slowdown early on in the pandemic. And then the final point, which is leading to a surge in demand, is the change of the composition of applications. And this was highlighted during the pandemic. We have done work with the World Intellectual Property Organization, the United Nations body responsible for IP. And we released a report just a few weeks ago, which tried to identify why IP continued to surge during the pandemic. And what they found was that areas such as online retail, cloud computing, and consumer electronics surged. And that speaks to how the economy adjusted during the pandemic. Likewise, there was a noticeable increase in pharmaceuticals and medical supplies. That demand spiked very early on in the pandemic. So with all of that, what that has led to in Canada is for the first time in recent memory, we're facing a growing inventory and turnaround time for our trademarks. In response, we have engaged with many IP experts in the community, both domestically and internationally, on a way forward. And in early 2021, we launched a recovery plan aimed at reducing backlogs and turnaround times in trademark examination. Our plan comprised a series of measures to improve timelines, and they included increasing capacity, adopting new technologies, and we launched a new service in April of this year consisting of automated pre-assessment of trademark applications. So with that, just over the last few months, we have noticed a considerable change in our ability to tackle the backlog. If we had not taken action last year, our backlog would have surpassed 187,000 applications. But what we found with our work is our backlog peaked at 160,000 in July, and last month was decreased. So we're on a good path presently. We have a long way to go in terms of addressing our backlog and getting back to pre-surge timelines and inventory. So I'll stop there, Chair. Thank you.
Thank you very much, Mr. Gigaras. And in the next couple of minutes, IT will reach out to you to try to fix the issue with the camera. So bear with us. And now, je passerai maintenant la parole à Monsieur Blanchet.
I will now turn to Mr. Blanchet for 5 minutes, please. Thank you, Mr. Chair. Good day to all, and thank you for inviting me to join you. I'm here to discuss a new public policy that exists in Quebec, a type of organization we've had for a number of years, and I've carried out research on this approach, which we call mutuelles de formation, which are mutual training organizations which exist to support small and medium-sized enterprises by providing common services to all their members and to help counter the labor shortage. So I've published my research with the help of the Institute for Research on Public Policy. As you know, labor shortages are a challenge for all sectors across Canada. Whatever the size of your business, small, medium, and even large enterprises are all affected by current labor shortages. They're clearly with us for a while, given the demographics that we foresee. Labor shortages are a thing with us, and they'll a thing to stay. So to deal with this, we need to look to training. Training not only attracts labor to small and medium-sized enterprises, but also helps maintain labor, retain labor, and also helps these enterprises become more successful, more effective, able to produce more with less labor. That's what happens when you train people. Studies have shown this for many years. That said, there is a problem for small and medium-sized enterprises, given that they do invest a good deal less in training than large companies. And that's because they don't have the revenue, they don't have the knowledge or the in-house personnel, staff to develop training programs. That's why it's very important to think of as many ways to help them as possible. That's why we've created these mutuelles de formation, these mutual training organizations in Quebec. As you know, there's a well-organized system for training labor in Quebec. A number of institutes have contributed to this based on legislation in the 90s. So we've been at this for 25 years in Quebec. A number of institutions touching on a number of sectors, all there to help develop labor, to train labor, and now to deal with the labor shortage. One of the tools has been these mutual training organizations that were developed in the early 2000s and have been referred to in Quebec legislation since 2008. So they're actually officialized now. And what's the aim of such a mutual training organization? It is to identify, to research and find small and medium-sized enterprises' challenges with regard to labor, and then to deal with the challenges, to do something about them. As we say, labor shortage, a lack of trained labor in 2022, and it's something that we can foresee for the years to come, given current demographics and the pandemic we've just lived through. So how does this work? Enterprises with an interest in training labor, and usually by sector, by the way. These are usually small and medium-sized enterprises in a specific sector, so they come together and state that they are interested in developing a mutual training organization, and they state this to, let's say, the Ministry of Industry, the Ministry of Labor in Quebec. And if there's sufficient interest, funding is provided to launch their new mutual training organization. That means that a director is hired, someone who's well trained for this job, and they are then in charge of going to meet the various SMEs, the employers, to learn more about their needs, what they're interested in, and come up with a thorough list of current training programs, what's available, what could be drawn on, or create new ones. And basically involve the sector by mobilizing resources. Resources can be provided by a number of organizations, all with an interest in training labor. The basic idea is to involve SMEs. Mutual training organizations will draw together resources, will combine the resources of their membership, of their customers, so to speak, and thus make it easier for them to pay for training, thanks to their working together, thanks to their joint undertaking, their shared resources. All this to ensure that training can be offered at lesser costs so that small and medium-sized enterprises will be able to offer training. Because it's really the cost of training that's the principal obstacle to SMEs actually getting involved in solving the labor shortage and training issues that they're facing. It's like a major barrier for them. So you reduce that cost by coming together, by developing a joint enterprise to provide common services to all members, and you overcome that barrier. So these are sort of a semi-public or para-public institution supported by both private and public sectors that work between the government and private enterprises. And they ensure that we're able to fill in the gaps. They support broad-based access to training, especially for employees who are not well trained, who need to find jobs in their sectors, to advance in their sectors. All this helps workers integrate their sectors and keeps them in their jobs and keeps companies well-staffed. It can be about material resources, organizational training. All this, by the way, is offered thanks to the mutual training organization, finding the best training at least cost, finding the trainers, and so on and so forth. All this is eased thanks to the joint undertaking. So I have studied 4 specific mutual training organizations in Quebec and seen how they have developed from 2008 through 2018, 4 of them. One working in the construction sector, another in graphic communications and graphics, another for elder care, that sector, and the 4th for child care from 1 to 5 years of age, that sector. What can I say? Well, there are winners and losers because you need the proper circumstances to really succeed. They don't all manage to get off the ground, to become financially independent, which is, of course, one of the main aims. They need to be efficient to succeed. They need to have a clear understanding of exactly what they're focusing on. They can't meet all training needs. They need to focus on specific labor needs, perhaps the most relevant ones, the ones that will really help their clients. And the Mutual Training Organization sets out at the very beginning to define its aims very clearly. That's essential. We can't try to do everything across an entire sector. That's step one. They must also avoid competing with other organizations to succeed. There are a number of sectors in which there are so many organizations, educational, private, all offering training. The idea is not to compete with these, but to work with them, organize shared approaches with them. Thank you, Mr. Blanchet. I will ask you to conclude briefly, given that we will run out of time. Yes, of course. So these organizations will succeed if small and medium-sized enterprises really get involved and back them. The employers, of course, the workers as well, unions must also support any mutual organization for it to survive. As I say, labor shortages are with us to stay, and we do need to use as many strategies as possible to overcome this obstacle to the success of SMEs. So, as I say, this is a semi-public institution. It ensures that we're working with current approaches. I'm sure we'll be able to continue hearing about this. We'll get back to questions later. Thank you very much. And now I would like to hear from Mr. Woodrick from the Macdonald-Laurier Institute. 5 minutes, sir.
Merci, Monsieur le Président. Good
Thank you, Chair.
And thank you very much for the committee for the invitation to appear on behalf of the Macdonald-Laurier Institute. For those of you who aren't familiar with us, we're a public policy think tank based in Ottawa. I think, in fact, the only sort of what you might call a full-service public policy think tank based in the nation's capital. We were, of course, very pleased to see this committee seized with issues of such great economic importance. It's a very broad topic, so it's sort of pick and choose what you want to talk about in your 5 minutes. And I'm going to provide a bit of a perspective on SMEs for the committee to chew on that some might find a little bit unorthodox, but given that part of the study involves productivity, I think it's an important consideration. And I think we could probably start with the fact that this study focuses specifically on SMEs rather than businesses generally. And we have to ask the question, why is this? I think we all know the answer why. And as practicing politicians, you will be acutely aware that small and medium-sized businesses carry a special and positive reputational weight in the world of politics. They are personal, they are local. The contrast between the relatable owner of a small business who lives in your community, and no doubt many of you know many of these individuals personally, and what we might call distant, faceless corporations, the difference could not be more stark. And the latter half of this equation, I would suggest, is very problematic when shaping policy. If small and medium-sized businesses have a halo upon them, larger businesses bear the burden of being the villains in this theater. And this leads, unfortunately, to policies that can tilt the playing field towards the little guy against the big guy. Now, why is this a problem? I would suggest it's a problem because most of the evidence suggests that if we're actually concerned about things like productivity, higher wages, equal gender opportunity, or even unionization rates, the reality is larger businesses severely outperform smaller businesses by a considerable margin. Just to take one example on wages, there was a recent study that shows that large firms, which is defined as firms with more than 500 employers, they tend to pay workers on average 44% more than small firms. Productivity, of course, another issue of importance to this study. In many industries, larger businesses can leverage scale, research and development, network effects, and better weather global competition by virtue of their size. So that is to say there are some significant advantages to larger businesses that small and medium businesses simply do not have. The other challenge with small businesses that's difficult to accept is that the reality is that the vast majority of them either do not succeed beyond a few years or grow to a very limited size. Now, there's of course nothing wrong with this. Not every business can succeed, and not all of them need become Goliaths. but it does illustrate the difficulty of putting an overemphasis on SMEs if we're looking to them to be a major driver of productivity growth. Now, another issue that this study focuses on is competition, of course, and I think John Peckman highlighted a lot of this with his remarks, and I agree with much of what he said. I think anti-competitive conduct is something rightly that policymakers need to be seized with. I think, of course, there's a consensus across the political spectrum that anti-competitive conduct and behavior is bad for Canadians. But note that this is actually a size-neutral statement. It is not that being big makes you anti-competitive. It is the behavior. Both large and small businesses can act in anti-competitive ways. I think instead, so competition policy needs to remain focused on behavior rather than on size specifically. And in fact, I think this is a useful way to frame policymaking around business generally, rather than large versus small. I think a more useful framing might actually be old versus new, since there's quite a lot of evidence that newer businesses tend to be more dynamic, more growth-oriented, and more innovative than older ones. So I think when shaping policy, this might be a useful way to look at it. The last thing I'll mention, so I know I have a short amount of time, is a study that Macdonald-Laurier participated in, a ranking called the Subnational Innovation Competitiveness Index, which came out in June this year. What this study did was it ranked all 92 jurisdictions in Canada, the United States, and Mexico on their innovativeness of their economy. There's a lot of good news in this for Canada. We rank very highly in terms of our skilled workforce, our immigration system. We have a highly educated population, good linguistic ability. Some of the downsides, though, that probably should deserve some focus from policymakers include the number of patents. Patents are much lower in Canadian jurisdictions than in the United States. Gross value added per worker in manufacturing is lower here. And perhaps most alarmingly, the economy-wide business birth rate. Entrepreneurship has a weak pulse in Canada, according to this survey, so something we should certainly be concerned with. Thank you.
Thank you very much, Mr. Woodrick. We'll now move to the first round of questions with MP Gray for 6 minutes.
Great. Thank you, Mr. Chair, and thank you to all the witnesses for being here. My first questions are for Mr. Woodrick. I'm sure with your background that you're well aware of the different red tape reduction measures in place at the federal level. And through reporting obligations via the Red Tape Reduction Act, the 2021 annual report showed the regulatory burden on businesses increased in 2020 to 2021 by 4,606 new regulations. I know, being a former small business owner myself, trying to keep up with new regulations and, establishing compliance plans can be incredibly costly and time-consuming. Do you believe increasing regulatory burden makes it more difficult for small and medium businesses to operate and makes them less competitive compared to other jurisdictions?
Well, thank you for the question. I think the obvious answer is no, they don't. I don't think any business owner is telling you that they're desperate for more rules and paperwork to fill out. I think we do need to look at streamlining. I know it is a constant battle. Every jurisdiction faces this. I think a lot of regulation that is brought in is well-meaning, but I think that needs to be weighed against the administrative burden and, frankly, against the burden that already exists. We find that there is a sort of one-way ratchet effect with a lot of regulation. It tends to get piled on, and old regulations are not repealed or streamlined at the same rate as new ones are added.
Great, thank you. There was formerly an advisory committee on regulatory competitiveness, which ended in 2021 and is yet to be reestablished in any form that we're aware of. How important is it to have entrepreneurs and small and medium businesses at the table to gain stakeholder input and feedback rather than to have the government knows best top-down approach when developing policies?
I think as a general rule, it's very good to have practitioners of anything that you're doing a study or having a commission to look at participate in the process. Again, I believe most people who run for office and serve as politicians mean well, but that's very different than having the firsthand experience on the ground. So I think it's very important to be at the table.
Great, thank you. I'm sure that you're aware that there's a number of automatic tax increases, whether it be carbon tax, excise taxes on beer, wine, spirits, payroll taxes, which go up every year, burdening small and medium businesses with more costs here in Canada, all while occurring without a vote in Parliament. Do you think that annual tax increases should be voted on in Parliament?
Yeah, you know, obviously, the tax burden is a cost like any other cost a business faces. Higher costs make it harder to stay afloat. I do think it's a general principle is that if you're going to raise taxes on the citizenry, you should have to face a vote in Parliament to face the music, so to speak. Otherwise, I think the public has very little recourse and sort of very little defense against taxes that are raised automatically. So yeah, I absolutely agree that if taxes are going to go up, they should be voted on in Parliament so that they're on the record.
Thank you. My next question is, you wrote an article regarding a survey on the state of housing in Canada and stated, quote, participants expressed growing concern and frustration stemming from the cost of owning a home, growing pressures on the cost of living, post-COVID economic conditions, and more. And I'm talking to a lot of young adults all the time who feel hopeless, who are considering leaving Canada. And we've seen stats that international students are also looking to not stay due to costs in Canada. And the effects this have on the financial stability has also disincentivized young people from starting new businesses. So how do you view Canada's high inflation, regulatory burden, high taxes, and expensive housing are affecting young adults and making Canada uncompetitive to keep young adults here?
In short, they're discouraging. To be fair, other jurisdictions face most of these problems to a different degree. I think uniquely in Canada, the housing issue is outsized relative to most of our peer countries. In our view at MLI, this is primarily, but not solely, a supply issue. And I think that the federal government and the provinces need to look at all tools at their disposal to overcome some of the incentive barriers at the municipal level to increase supply. So I think, look, too much of any of those challenges is devastating. I think, as I mentioned earlier, the economy-wide birth rate of businesses is very low here. That probably explains why. But housing in particular is something that I think governments need to be seized with as a major priority in the coming years.
Great, thank you. You also read another article where you referenced what Canadians are looking for from their government, and you said they, quote, prefer that whatever governments are put in charge of, they fulfill those responsibilities reliably and competently. And you also said, quote, it really should not be controversial to suggest that any organization that is not doing a very good job fulfilling these current duties should probably pause before adding to its to-do list. And I know my constituency office of Kelowna Lake Country, like I'm sure many MPs, I'm sure, we've been inundated with constituents reaching out due to delays at virtually every federal department office, and it is creating a lot of burdens, especially for small and medium businesses, whether they're trying to resolve, CRA issues or worker visas, or if they have employees who need a passport renewal to go to a conference, all kinds of different scenarios, and these affect small and medium businesses. So my question is, if the government is looking to add to some of their mandates in their work plans, whether it be to the CRTC or health programs or many other things, it is now the time to be doing this while departments aren't providing some of the basic services already that Canadians expect from their tax dollars?
Yeah, I would suggest that would be unwise. I think oftentimes governments face a choice between doing very many things not so well or fewer things better. I think now is the time for the latter. Look, there's always going to be a debate in this country about how much government should do. That's normal, that's healthy. But whatever we settle on, government should be doing it well. I think passports in particular have become sort of symbolic of Canadians' frustrations with services. I believe that most Canadians are happy to pay their taxes if they feel they're getting good value for them, but they get frustrated when they see their taxes going up, but their services stagnating or in decline.
Thank you very much, MP Gray and Mr. Woodrick. I'll now move to MP Dong for 6 minutes.
Thank you very much, Chair, and I want to thank all the participants for coming today and to give us your testimony. My first question goes to Mr. Jagaris with regard to the trademark situation here. You mentioned that I think you said last year you received over, I think it's 112,000 applications between trademarks and IP applications. What's the average processing time for these applications?
Thank you very much for the question, and apologies for the technical issues I've had. If I could turn to my colleague, Ms. Mampierre and Yana Goyette, to respond to the specifics. Thank you.
Thank you, Konstantinos, and thank you, sir, for the question. It does depend. We have, in fact, on average, now seen a decrease of 30 months for a response for the office with respect to overall domestic applications. We do have a number of streams, like if it's coming from international, we have obligations under Madrid system, as Konstantinos alluded to earlier. And the obligations for Canada is a response within 18 months, and we are meeting that obligation since we joined the treaties in 2019. However, we do take also measures to accelerate some applications when they are needed, for instance, for court actions or in response of COVID applications and so on.
Thank you. Sorry, I got a few questions. I don't mean to be rude. So what you're saying that for average domestic applications, it takes up to 30 months, but for international applications, it's 18 months because Canada has obligation to fill. And how does these numbers compare to other jurisdictions?
Thank you. With respect to the international ones, they do compare because it is the obligations. With respect to domestic, we are seeing that here in Canada, we're a bit slower. And as Konstantinos mentioned, we are taking steps to address these issues. And now we have peaked with respect to our inventory, and we're improving turnaround times. By building capacity, we've hired over 100 examiners for trademarks at this since 2020. And we're also now using or deploying better technologies such as artificial intelligence to automate some processes, which is really helping us.
The question was, how does that compare to other jurisdictions? Let's say United States or UK or Japan.
We are looking at sharing best practices with our international counterparts. Canada is slower than these jurisdictions, but we are looking at the similar measures that they've put in place, and we know we're on the right track given the type of best practices that we're sharing with these jurisdictions.
That sounds great. Last question on this topic. What's the trend? Let's say 5 years ago, what was the processing time? Just give me an idea. Just give me some context.
We were about 15 to 16 months prior to joining the treaties where we had the surge that Konstantinos mentioned about.
So 15 to 16 months before the treaty. And now, because of obligations, international is 18 months and domestic is 30 months. Can I make the sort of assumption or hypothesis that it was because of the entering the treaty that is because of the lack of resource that is slowing down the domestic application processing?
It's a fair assumption combined with the COVID-19 situation and then indeed the very high success for Canada following the accession to the treaties.
Thank you. I want to change the channel a little bit to Monsieur Blanchet. With regard to the labor shortage, we've seen that there's underutilized groups in our society, i.e. the youth, older workers, new immigrants. What can we do to change this? Because it does impact SMEs' productivity. Because can the government do something to encourage underutilized groups to contribute more into our economy?
Oui, bien sûr, absolument.
Yes, of course. Yes, indeed. There are ways. For example, taking Quebec as an example, Quebec's institutions, where emphasis is put on training, on designing training, specifically for groups which are underemployed in the workforce. A number of institutions contribute to this, these mutual training organizations. That's what I spoke about. And I was focusing mostly on those that are sector-based. There are also other semi-public institutions linked into the same overall system in Quebec, which work specifically with underrepresented parts of the population, women, let's say, elder people, older people, or younger people, people who have dropped out of their studies, have dropped out of school, let's say, and are now 22, 23 years old and are looking for training.
Same question to Mr. Peckman. I've seen the growing use of online platforms, and they've, especially in the general labor market, they've kind of sucked in a lot of those resources. We've all had conversation with Uber drivers who's a trained professional now driving Uber, and we've seen increase of that. What's your comment on it? What's your thought on this in terms of productivity of our labor force in Canada?
And a very brief answer, Mr. Peckman.
Well, thank you for the question. Very briefly, clearly to have a more diverse workforce is a goal for government. Allowing for open, unfettered markets to function freely, I think helps with that. Clearly, there are places where government subsidies and intervention is required to facilitate more diversity. I think the program that Mr. Blanchette was mentioning is one example of that. But as far as the Competition Act itself, it does not actually target, labor and diversity and those types of issues. So it's hard for that particular piece of legislation to assist in any significant way, in my view.
Thank you very much. Je passerai maintenant la parole à Monsieur Lemire pour 6 minutes.
And now over to Mr. Lemire for 6 minutes, sir. Thank you, Chair. And thank you to all our witnesses for your presentations this morning. I think that this really speaks to the study that we've been carrying out on SMEs. I'll start with Mr. Peckman. What is your understanding at present of the legislation in Canada? What do you think of it? Legislation covering competition. Do you think we should reform it? Or is it the right time to get at this and to rethink the whole structure?
Clearly, in my opening statement, I commended the government for taking some baby steps towards strengthening competition laws. I firmly believe more needs to be done, particularly given that competition laws are a huge macroeconomic policy lever that's been neglected, in my view, to deal with increased productivity and competitiveness. There are areas of the legislation that need an upgrade to deal with the digital economy. Our merger controls review process has some antiquated provisions dealing with efficiencies that need to be looked at and revised in order for there to be more robust competition in Canada. Market study powers. The fact that the Bureau doesn't have them means that the Bureau doesn't have an in-depth study of industry sectors where there may be huge competition issues and can make recommendations to remove regulations that can be problematic, or giving other advice to governments to make it much more competitive. These tools are used in other jurisdictions, whether it be the EU, the US, Australia, and they have informed legislative change. Canada, unfortunately, market studies to advocate are done on a voluntary basis. The Bureau had some resource constraints. It takes away from their enforcement function. So I think more attention needs to be placed on that. And lastly, a competitiveness council, as I suggested, would ensure that there is some oversight to making sure Canada has got regulations and policies that promote productivity and competitiveness, very much like the United States has this competition committee that reports directly to the White House and to the President. Something akin to that, I think, would be helpful to Canada. And in the context of small businesses, clearly more competitive markets, a better marketplace referee to call fouls more efficiently will help small and medium-sized businesses as well.
Merci. Étant donné le temps limité.
Thank you very much. Given that we have so little time, I'm now going to turn to Mr. Georgas with a question about intellectual property. Somewhat similar, my question. What is your view of current legislation in Canada, and would it be a good idea to reform it, to review it, and change it to ensure it meets current needs?
Merci beaucoup.
Thank you very much for your question.
With regard to the legislation, we continually look at our IP legislation in Canada. And likewise, with the trade agreements that we have made over the years, whether it's with the European Union or as part of CUSMA, we use those as opportunities to ensure that our legislation is up to date and internationally harmonized. As I mentioned earlier, most of our applications come from outside of Canada, and many applications also file abroad. So we work through these trade agreements to ensure that our laws are up to date, harmonized, and consistent. Merci.
Thank you.
Monsieur Blanc.
Thank you very much, Mr. Blanchet. Labor and training, these are provincial areas of competence. So what are your expectations? Why are you here speaking to the federal government? How can the federal government help you out with this? Of course, the federal government has, ensured that funding is available to individuals for training. It also has supported training. There are federal government initiatives through the Department of Labor here and Labor Development here at the federal level. A number of organizations are available to work with the provinces or to work directly with the population through organizations, institutions set up across Canada. Then, of course, there's the Quebec model where powers have been concentrated in Quebec, but the federal government does have an ability to work elsewhere across Canada using a similar approach, not exactly the same as Quebec's methods, of course, but using something similar to what Quebec is doing and allowing various provinces to adopt and adapt things to meet their own needs. Across the various provinces and territories across the country. That being said, provinces are the leaders of this programming. And the federal government helps, often offering funding to help them start up new projects and so on. Then, of course, it's up to small and medium-sized enterprises to demonstrate their level of interest. And, of course, they are the winners. They're the ones who benefit from these new undertakings, these new approaches and organizations. Everyone gains when it works well. Thank you very much. I know that I tend to ask questions right now, but I'll just drop this. I know we're running out of time. Yeah, thank you so much, Mr. Lemire. Mr. Massé, I now turn to you for 6 minutes.
Mr. Chair, and thank you to all the witnesses. I'm going to start with Mr. Peckman there. With regards to continuing discussion with the United States, I mean, what's kind of the overall assessment? I mean, I think that Canadian consumers are treated like a colony in many respects by many of the large manufacturers and corporations. I'll give you a good example is Toyota. During their abysmal performance on the recall for brake pedals that were a deficiency, and we actually broke the story, and also that it was software, it wasn't actually a physical thing. They insisted it was a physical thing. Then they insisted it was the mat. It led to accidents. It led to serious problems. But in the U.S., their citizens actually got better service. They got their vehicles picked up if they wanted to, like in the state of California. They got replacement vehicles. They got actually a massive investment for R&D as part of the settlement. Over here, we didn't get any of those things. So can you give some insight as to when there is identified competition issues related to public safety and other matters, do you think that Canadians get treated the same as our American counterparts, especially in the auto ones? We're integrated, and we actually have the same emission standards, the same standards for quality, and as well road as well. So it's interesting, though, when it comes to warranties, recalls, and so forth, we're not treated the same.
Thank you for the question, Mr. Massé. In terms of the treatment of consumers in Canada vis-a-vis the U.S., obviously there's different rules and regulations in the U.S. than there are in Canada, particularly dealing with consumer protection and antitrust. The antitrust laws in the U.S. are very severe, severe penalties, including very active private class action matters that allow companies and consumers to advocate for themselves before the courts and obtain damages for conduct or by companies. In Canada, nascent in some of the areas, like on the class action side, that's available to consumers when you're dealing with cartels, criminal conduct, such as price fixing and bid rigging. But on the other types of conduct, such as abusive dominance and other market type of restraints. The Competition Tribunal is allowing access, but there is no damages provision, so that kind of mutes the effectiveness of that tribunal. I mean, it does help free up some of the conduct to make it more competitive, but the consumer redress piece is kind of left behind. So I think you really do have to look at the jurisdiction's consumer redress features, which I think we're a bit behind on the U.S. In terms of our legislation for competition and consumer protection, we're close. Again, we do need to make some tweaks to align ourselves with the U.S. on the merger side, for example. I mentioned the efficiencies process. Consumer protection, I think with the recent amendments, the damages have now significantly, or the potential administrative monetary penalties that can be imposed on companies have increased. Again, that will just draw their attention. I don't think companies intentionally intend to discriminate between the two markets, but their attention is focused where their costs are higher and where there's more liability. And Canada being a smaller market, I don't think it draws their immediate attention. Large markets like the U.S., Europe, is where they pay attention, and they'll get to Canada, and that's what we've seen often when you're dealing with international issues.
If we leave those holes open, I mean, is this something that we should actually, I'm also the international trade critic, and I've always argued should be part of our trade agreements. I mean, if we're going to integrate our markets and we're going to have similar rights for corporations on their competition and also massive public investments. Most recently, we've had significant public dollars going to many corporations in many different industries. Shouldn't there be at least some thought? Should we maybe bake them into trade agreements versus trying to recover later on by doing separate legislation to try to bolster, which I do appreciate the specifics you did for the Competition Bureau update. I think those are all really good suggestions. Should we try to bake those things into trade agreements, or what do we do now? Like, we just signed another agreement with the United States, but we didn't include consumer protection.
Right. So again, I have to be careful not to speak outside of my lane and outside of my expertise. So I'll focus on competition law. And specifically dealing with trade agreements. There are provisions in trade agreements that deal with harmonization of competition laws. However, in terms of the consumer protection side, I'm not aware that there is that detailed harmonization attempt, as you're suggesting. But the trade agreements generally do try to link up our competition policy and approaches. Again, it's not clause by clause, and so the devil is often in the details. There's attempts to cooperate, attempts to have similar types of provisions, but there is nuances that sometimes really matter.
But maybe that's where actually we're failing Canadians in the sense of doing follow-up legislation then to match those things that we do on the trade front. I mean, we finally got in some of those things on health and safety, worker rights, environmental issues, and so forth. So I do want to ask you, though, about expand a little bit on the independence of the Competition Bureau and maybe resources that we should have. I really feel that those are important factors that we have, and the independence in particular, especially when we have the disillusion of them, basically the media no longer doing investigative reporting as much because it's so costly. They're also litigated if against them. So we've lost a chapter in our journalistic elements because of a series of different disruptions that used to provide some type of exposure of corporate malfeasance. And I'm wondering whether or not there should be more independence, as you mentioned, and resources for the Competition Bureau to fill that void.
Yes. So the thesis in my paper that I mentioned, and I've been advocating for some time, is the Competition Bureau is currently situated as sort of a sector branch within Industry Canada, or the ISED, Industry Department, and as a result has to report. There's administrative and financial responsibilities there, and sometimes when there is a program by the department where they need funding, it'll be across the board, and the Bureau ends up providing some of its budget towards superclusters or whatever the initiative is, taking away from the resources of the Bureau. And so while I was commissioner, resources of our organization diminished over time as these asks continued. In terms of the independence of our investigations, yes, the department is hands-off. We just give a heads up that we're about to take an action. That's the extent of it. But I think there is a chilling effect when the department that the Bureau is situated in and reports to is in the business of also promoting a business, and it's hard to be a referee against those businesses when your higher ups are actually subsidizing, encouraging these companies to through subsidies or grants. It creates a conflict. It's not transparent. It just chills, and it chills the Bureau's advocacy sometimes in certain sectors because of the activity of the department. I'm just saying it'd be a lot cleaner and more efficient that Canada have, like the rest of the world, an independent competition authority, not embedded in an industry department, which is the number one thing the OECD recommends to developing agencies not to do.
Chair. Just really quick.
Very
so
quick, Mr. Massey.
More similar than to like the privacy commissioner or something complete.
Yes, that would be my recommendation. They report directly to Parliament. They're free. They can be more outspoken, can be more effective. And, of course, they'd be more accountable for their resources to Parliament as opposed to being buried within a department where their resources aren't protected. They are not protected. They are exposed to the department and their takes. So having them independent makes them, I believe, a better agency.
Thank you very much, colleagues. We're at the end of the first hour, and with your blessing, I would propose that we go forward for at least 15 minutes more, so we can do the first part of the second round. So every side gets to ask, has the opportunity for more questions. Would that be amenable to all of you? Okay. So, and if our witnesses can stay with us for just a little longer, I'd say 15 to 20 minutes. So we'll go now to Mr. Cram for 5 minutes.
Thank you, Mr. Chair, and thank you to all the witnesses for joining us this morning. Mr. Woodrick from the Macdonald-Laurier Institute, I found your opening presentation to be very intriguing. For a minute there, I thought you were going to be very critical of small businesses compared to large businesses, but as your presentation went on, the conclusion that I came to is that if we're going to increase the standard of living in this country, we need to grow small and medium-sized businesses into large businesses. Would you agree?
Yeah, I would agree. I would also say that some small businesses by their nature are just never going to be big, right? I mean, you think of a lot of these small businesses or communities. Don't get me wrong. You patronize a lot of them myself, right? They may run a small restaurant. They may run a small business in their local area. They may provide a good life, support a family, or have a dozen employees. But the reality is, most of these entities will never become giant businesses that employ thousands of people, and that's fine. But if we are really keen, and we do have a productivity issue in this country, I think everybody knows that. Putting too many eggs in the small business basket to address that, I think is just is not a great idea.
So for those small and medium-sized businesses that have the potential to grow into large businesses, what do you see as being the major barriers for growth in this country?
Well, look, the regulatory burden has already been brought up. I think there is room for government support here. I think, for example, Mr. Blanchette's presentation is an intriguing example. I think anything that government can do to connect smaller businesses to technology, because I think there are a lot of entrepreneurs who know their craft, who know their industry, but they don't know how to leverage technology. So anything governments can do to connect these businesses to technology will make them more productive and give them a better shot at getting bigger.
Okay, thank you very much. I would like to change gears now to Mr. Peckman. With the creation of the Competitiveness Council, I found that a very fascinating idea. Now, I just want to be clear, when we talk about anti-competitive behavior, are we talking about just price collusion and price fixing, or just a lack of competition in general?
So anti-competitive behavior is identified in the Competition Act and recently amended as well as any conduct that enhances, preserves, or creates market power, first of all, so the companies that have that, and then engage in conduct which is exclusionary, disciplinary, or predatory, and now adverse to competition. So it's a pretty broad basket, but basically it's conduct engaged in by companies that are dominant, have market power, that harm the entry, access, participation of other companies in the marketplace. And so the legislation currently exists to deal with that. The Competitiveness Council, in my view, should deal with advocacy, advocating to government to remove regulations that harm competition. Interprovincial barriers, barriers to foreign investment into the country that would, again, increase competition depending on what sector, whether it's telecom, banking, or just go down the list where there are international barriers to entry. So a competitiveness council would give high-level advice to government on areas to target to increase competitiveness and productivity in our country.
SMEs in Canada pay some of the highest credit card processing fees in the world. If we went with your approach and we adopted this competitiveness council, how would the council deal with high credit card fees?
Again, it seems to be a very narrow sectoral issue, which I would commend the Competition Bureau to study through a market study and then give recommendations as opposed to a more high-level approach. It's our credit card issues. We've dealt with those in the past at the Bureau. As you may know, there's an order that was imposed on Interact for debit cards and debit fees, which imposed very low rates, and that was a result of the work that was done, good work that was done by the Competition Bureau. Again, if there are some anti-competitive behavior behind those high rates, again, that would be something the Bureau would take on with its enforcement mandate. But I would suggest it might be worthy of a market study, and recommendations could be given to the government to change rules with finance or whoever to allow for a more competitive market, and which could perhaps lower fees for small businesses. Unfortunately, credit card rates are pretty, fees are high for merchants around the world. It's not just a domestic issue. But I'm sure that a study could help with some ideas, because it's not clear what the answer is. Following one of our cases before the Competition Tribunal, dealing with credit card rates, the tribunal said maybe this is an area for regulation, because market forces just don't work properly.
And Mr. Chair, I think I'm at
I'm
time.
sorry, Mr. Cram, you're out of time. We'll now move to MP Gahir for 5 minutes.
Great, thank you, Chair. If I have any time left over, I'd like to share it with MP Dong. I'd like to thank the witnesses for making time for the committee. My questions are for Mr. Georgaris. So you spoke about the challenges that are involved in this current regime, about the complexity about the process and the time to acquire IP. Could you focus on the complexity part of it, of why this regime is so inherently complex and how we can make it more accessible to small businesses, to startups, to underrepresented groups?
Thank you very much for the question. Why is these systems so complex? What we are providing here are intellectual property rights, and these rights define the boundaries of an invention, an idea, and it also gives the applicants a tool that they could use then to trade with, license, and protect in the marketplace. So to have that IP right well defined, it does have a lot of complex processes around it, and it must adhere to domestic laws as well as treaties that we're part of. So as a legal instrument, it is complex. As I mentioned, what we are doing is providing very focused awareness and education material to applicants as well as potential applicants to help them understand the value of IP, whether or not they need it, and also how to navigate the system. So our job here is to provide that information to help SMEs go through the process. For larger companies, of course, they're well versed in IP, and the complexity is less of an issue. Thank you.
Great, thank you. So my second question is, a gentleman from your team mentioned that AI is being used in the process to streamline it. Could you expand on that a little bit?
Yes, in that I'll turn to my colleague, Ms. Mampierre, to elaborate.
Thank you very much for your question. We've recently, in fact, looked at automation of some of our repetitive element of our process, really to be able to provide information to applicants with respect to goods and services. So when they apply for a trademark, they have to define which goods they want to protect or which services they want to protect. And using automation, artificial intelligence, we're able to fast track those elements and provide those informations, which in terms really goes to improving the time it takes us to return to the applicant with a decision. Thank you.
If I may add to that, and again, my apologies for the technical challenges here, but what Mr. Pierre described, again, is a tool to help our examiners. Ultimately, the decision of trademark registration falls with an individual trademark examiner. It really is a tool in the use of those technologies. Thank you.
Great, thank you. Chair, I'd like to cede the rest of my time.
Thank you, MP Dong.
Thank you, Chair. My first question is to Mr. Woodrick. Are you aware that the 2022 budget, changed the tax, I guess, the tax ceiling to allow small business to grow into medium business? What's your thoughts on that? Do you think that was a good move?
Yeah, look, I think there was a ceiling, right? If you create this has always been the debate over the small business tax rate as well, right? Is that you create disincentives for businesses to become bigger. So I think anything that smooths out that process, that makes it easier and creates fewer barriers for businesses to go from small to medium to large is a good thing.
So the small business still enjoy lower taxes now that I think the ceiling has lifted to $50 million, so allowed them growing to medium-sized business. And also, what we hear a lot, especially during question period, that the government's being criticized sometimes providing subsidies to large corporations, and because they are qualified under, especially during the pandemic. What's your thoughts on that? Do you think that these benefits should be more target towards small, medium size, or large corporations should also qualify for these?
Well, I think, first of all, the pandemic's obviously a special circumstance. So I think the sort of usual arguments against government subsidy, private business probably don't apply in the pandemic circumstance. But otherwise, no, look, I think the wisdom of subsidies should be questioned significantly. I'm a skeptic of them. I've been an advocate against them in various capacities for close to a decade now. So I don't think that the eligibility for a subsidy should be dependent on size. I think if you do decide to do it, and I caution that you do, it should be, you shouldn't prefer a business as a recipient based on their size.
Would you agree that during COVID, the rental subsidy and wage subsidy was instrumental in saving some of the large and small corporations in Canada, and making sure that people got employed, and making sure that our economy remains strong coming out of COVID?
Very briefly, Mr. Woodrick.
Absolutely. I don't think anybody argues against the measures. You can Monday morning quarterback it, but they had to move quickly, and so they were going to be perfect.
Merci beaucoup. Je passerai la parole à Monsieur Lemire.
Thank you very much. Over to Mr. Lemire for 2 minutes. Thank you, Chair. Mr. Beckman, as a prior commissioner, have you had a chance to look at the junior hockey issues, competition between the different leagues, and the status of a professional player for those of 18 to 20 years of age, and junior hockey leagues across Canada in general?
Well, as the former commissioner, we may have received complaints about that issue, and of course at the commissioner level I wouldn't have made it to my level, but the issue of labor rights, rights of hockey players, clearly can have competition issues with dealing with large leagues and teams, and so it comes down to bargaining often. The Act does allow labor to bargain, so there could be some bargaining issues there. But we did intervene on occasion to allow certain teams to move to different locations because there were barriers to movement. But in terms of drilling down to the player level, that may be an active issue or an issue that took place after my term as commissioner. I just can't give you a comment on that, and if I could, it would, a lot of that would be confidential. But clearly there are potential considerations there of the rights of players in a monopolized league the imbalance of power, and there could be potential abuses in that scenario. And again, if the Act or the Bureau could take action and it was a priority, I'm sure they would look at it closely and do the appropriate thing.
Merci beaucoup.
Thank you very much. So there's a section 41, 1.1 on this issue. Might anything have been done about this? Is it acceptable to restrict the possibility of the players have to participate? Are there excessive conditions on participation in professional circles? So anyway, thank you for your answer. I would have liked to hear more information, but I understand that perhaps this is something we can pick up later, or that your mandate doesn't allow you to speak to this. Thank you, Mr. Massé. 2 minutes and 30 seconds.
Credit card rates, I think, and credit card industry, I think that's, financial management systems in our country is probably the biggest inefficiency in our economy. I mean, on the consumer side, we're at, upwards of 19 to 27% on some credit cards per general, even some higher, some lower if you get the right one. But one of the ones that I asked the Bank of Canada about was the charges and service fees to SMEs that's taking place and the lack of competition there. And whether or not they had actually investigated their own credit card for small, medium-sized businesses. And they said they actually did a study in the past. Is this what kind of might be referring to in terms of, like, if we don't see much adjustment in the markets on that we might actually look at regulation to make sure that they're in line? I mean, there's a disproportionality in terms of amount of investment that these companies have made to receive a profit based upon movement of money amongst customers and consumers. It seems rather inefficient for SMEs to have to rely upon this cabal system that they have and losing profit margins when a convenience store only makes 2 or 3 percentage points, or a gas station per sale, and meanwhile it's almost all eaten up by credit cards.
Complex area. Obviously, there is a benefit to small and medium-sized enterprises to using credit cards. Clearly, it helps with consumers and attracting business. And in terms of what is the right price for that right to use these cards, or the ability to use the cards, is a very tough question. What is the right price? The market forces usually determine that. And again, if the prices are too high, or there is what we call an exercise of market power, means that there could be a monopoly situation, or just markets are failing. And a study may look at these issues, the complexity of these issues, and provide recommendations on how better to go forward to make sure that the process is, if it's perceived to be unfair to some certain customers, ways of perhaps providing solutions to that situation. Because again, as I sit here.
So hence, if it was independent, like the Auditor General or something like that, there'd be credibility amongst these studies because it would come back independent and have to report to Parliament, not to anything else.
Well, that is obviously important, that the recommendations are unfettered and independent based on the evidence and independent experts if they're used. Clearly, the Bureau undertook a fintech study. When I was commissioner, we made recommendations to finance on how to introduce more financial technology services to help with competition. That is moving through the process, and hopefully when there's more fintech competition, you may see activity in the credit card side as well.
Thank you. Thank you, Mr. Chair.
Thank you very much, and I wish to thank all witnesses. Peut-être j'aurais juste avant de conclure une.
Perhaps before we wind up, I do have a quick question for Mr. Blanchette. You were mentioning the federal government's benefits and support for labor training 2018 budget, if I'm right on that. Have you studied the how much uptake there is for this? No, not yet. It's rather recent, the 2018 budget. Did emphasize work on the income statements before 2019, all this during the pandemic in brief. But it is certainly a topic I'm very interested in. To what extent the population, the people are actually using this benefit, are drawing on it. It usually takes about 5 years before you have enough data to tell. 2024 would be the right time to start a study on the popularity and the use made of this benefit, to this support. So to be picked up on later. Thank you.
Today. It was much appreciated. This concludes our studies on SMEs. So thank you for being with us on this last meeting. I now call this meeting, I adjourn this. I suspend because we're going to meet again in camera. So I suspend for 5 minutes and we'll be back in camera for committee business. Have a great day to our witnesses and thank you again. Meeting suspended.